Hi, this is Jim Cunningham. We're going to talk about how a trust saves you more than it costs. So, yes, there is a cost setting up a living trust, typically with a lawyer. There is a cost in administering that trust, or all the stuff you have to do when somebody passes away or becomes incapacitated. But that is money well invested because, as you are going to see here very shortly, it's a big payoff. And for, the more assets you have, the more complexity you have, the more tax, like income tax issues and capital gains tax issues, the more value an estate plan can deliver. And what you're going to see is this is really just pennies on the dollar because having a living trust can save you money. Sometimes it can't. I mean, I suppose there are circumstances where it's over-engineered, there aren't enough assets. We don't see that a whole lot. What we do see a whole lot are people who pass away or become incapacitated, have no plan or have a will-based plan, and it is quickly tens of thousands, if not hundreds of thousands of dollars. And we'll see as we go through the materials here how that happens. So an estate, if a person passes away and an estate is $1 million, the probate fees in California are about $46,000. It's $23,000 to the lawyer for the legal fees, $23,000 to the executor. There's a few $1,000s in expenses. But even what I would characterize, at least in California, as a particularly modest estate, $1 million is basically a house now in California. The probate fees are pretty significant. Also, the probate fees are based not on the net assets. They're based on the gross assets. So if you have a house that is valued at $1 million and you happen to have $950,000 mortgage on that property, you're not getting anything, right? All that money is going to go to probate fees. Probate is also public. So probate is public. It is not private. A living trust is private. This goes on typically for more than a year on probate, but anyone can come in and find out some pretty confidential information. The family of the person who passed away, the amount of the estate, what's in it, each asset in the estate, how much each person is going to inherit and when. This is all publicly available information, and it kind of freaks people out when they learn about that. So if large estates aren't transferred, passed from one generation to the next, and estate planning is about the peaceful transfer of wealth from one generation to the next. If big assets, so larger dollar amounts involved, if those are not transferred correctly, it can result in, frankly, unnecessary taxes or taxes paid prematurely. So we're going to talk about that. There are some assets like your IRA, though you're going to have to pay income tax, or after you pass away, your heirs are going to have to pay income tax on that. The question is, do they pay that right when you pass away, or do they pay that 10 years later? And that's for most people the question. I'd rather pay those taxes 10 years later, right? And you get the benefit of tax deferral. So we'll talk a little bit about that. If you're watching this on YouTube, go ahead and subscribe to our YouTube channel. And if you click the bell, you'll be alerted when we drop our content, which is typically every Thursday at 6 p.m. Pacific time. And so we record these webinars typically at noon on Thursdays. I'm Jim Cunningham. I'm a partner at Cunningham Legal. I've got over 30 years experience as an estate planning attorney. We have offices throughout the state of California. I am a certified specialist in estate planning, trust, and probate law. I'm also a real estate broker, securities, and insurance licensed, and a pilot single engine land instrument rated, although I am not current on being a pilot. So disclaimer, I'm a lawyer. I'm talking about probate. When I say you, there's no attorney-client relationship involved here. I am just simply giving an example hopefully in terms that normal people, that is people who are not lawyers, in terms of that normal people can understand. But really, this is not legal advice and should not be taken as legal advice. So the costs of not having a trust. So if you don't have a living trust, or maybe your parents don't have a living trust, or your spouse, this is actually pretty common. One spouse is really worried about what happens when the other spouse passes away. What happens if you don't have a trust? So there are several issues that pop up. And some of these are monetary costs. Some that might be harder to ascribe a dollar amount. Certainly you have the probate fees. Probate fees, by and large, are typically much more than the fees people pay to set up a trust and to administer a trust, which is all the stuff you need to do after a person passes away. So there is work that needs to be done. It's not that a living trust obviates or eliminates the need to do all these things. It just gives you the ability to do it outside of the probate court. So probate fees are a cost. Privacy, I put that as a cost. Now, that may be hard to quantify, but if you're like most families, most people don't want their personal information publicly available or publicly disclosed, and that's what happens in probate. So everything, family relationship, date of death, location of assets, all of this, extent of the family, right? This is how we do a lot of genealogical research. Is we look at probate filings, like who is related to whom when they passed away. Tax is obviously kind of easier to quantify. Creditor exposure. This is really interesting with probate. Probate not only is a public process, it is also designed, probate is fundamentally designed to pay creditors. It is not really designed to get wealth from one generation to the next. A living trust, the basic DNA, the structure of a living trust does not favor creditors, okay? It favors beneficiaries. So I would say on a very high level, you have this public versus private. A will is very creditor friendly, much more creditor friendly than a living trust. Now, does that mean with a living trust, you don't have to pay creditors? No. It just means you don't have to go out of your way to notify them and give them this forum and this opportunity to file a creditor's claim and have to deal with a judge. And there's just a lot more going on in the probate context than there is a living trust context. It's harder for a creditor to get paid with a living trust than it is in probate. And also family disputes. And, I've been doing this a long time, meet with a lot of different people. If there's conflict in a family, it may not matter if there's a will or a trust, but something to understand, if there is a will, it gives a forum, it gives a court action for that wingnut family member to come in and cause all kinds of problems. A living trust, there is no companion court proceeding that goes on with a living trust. Much harder for a beneficiary or someone, a wacky family member, it's much harder for them to wreak havoc in the post-death administration of an estate. So for those are different costs out there. What is probate and how expensive is probate? Well, probate is time-consuming, expensive, no privacy. We mentioned that. Normal probate takes 16 to 24 months. Probate courts are frequently backed up. Probate fees are a percentage of the gross value of the estate. So assuming no debts, no mortgages, no other sort of debts, probate fees range in California from 4 to 8%. Now, that is the combined executor and attorney fee. So again, on $1 million estate, the executor fee is $23,000, the attorney fee is $23,000, and that takes a couple of years. No privacy. Probate is a public process, and this means all documents filed, asset information, family details all become a matter of public record. It used to be a lot easier to search this on the internet, but this information is available. It may not be available at your fingertips on a Google search, but certainly is accessible. And remember, there are third-party companies that aggregate data and sell that data. So, just to think, oh, well, it's in the court file, but I don't really have to worry about it. No, I mean, that's going to end up in a database. So, family disputes, probate sometimes does lead to family disputes, especially if there are disagreements about what the will says or should have said, or what did mom or dad really want, how assets are distributed, which assets are distributed to whom. There are a lot of reasons. It may be that Sally didn't get the red bike for Christmas in 1962, and she's hated you ever since then, and that's not going to change. So whether mom and dad do a will or a trust, you're going to end up in court. Again, a little bit harder for Sally to rattle the cage and bring an action with a living trust than it is a probate, because probate, you do have a court proceeding and she can show up and vent. So on $1 million estate, the attorney's fee is $23,000. The executor fee is $23,000. Our firm does have a probate fee calculator on our website. So if you go there and you're wondering, gee, like how much is probate going to be on a $4 million estate? We have a probate fee calculator, and we've got a link for that. We'll put that in the notes on our YouTube video. Probate on a $10 million estate, $226,000. So they go up. Now it's not the same percentage in terms of it's a lower percentage, because the idea is, look, if it's a larger estate, there's not necessarily a $10 million estate isn't necessarily 10 times the amount of work. It might be, but it's not 10 times the amount of the fee, right? That fee's not going to be $400,000. It's going to be only $226,000. But still, again, the attorney's getting $113,000. The executor is getting $113,000. The larger estates can take longer for a lot of different reasons. A lot of times you're having to get tax clearance from the federal and state governments. before you can close out an estate, a larger estate. So that can take a little bit longer. So again, we have this probate fee calculator on our website, and we'll have a link in the notes here. And this is great because you can just plug the numbers in and say, how much is that probate going to be? So benefits of a trust: avoids probate. So the trust enables assets to bypass the probate process, right? It does not go through probate, transfers ownership from the person who set up the living trust, typically to their kids in a peaceful, non-court supervised process, maintains privacy. This is really important. A living trust is a private document. Now, there is a requirement when a person does pass away in most states, and California is one of them, to notify people who are named in the trust, as well as people who would inherit if there were no trust. Meaning, if somebody says, look, I've got 3 kids and I'm going to leave everything to these 2 kids, I'm going to disinherit this 3rd kid, that 3rd child still is entitled to see a copy of the trust, but not the public at large. It's not being filed with the court. It's not being, there's no requirement to make that public. A will, on the other hand, is a requirement to make it public, to make it a public filing. So this is how a trust maintains privacy, and the details of asset, what the assets are and how they're being distributed, that stays out of the public record. So avoiding probate, a living trust avoids probate, avoids the hassle, avoids a mandatory delay, maintains privacy, and can have significantly greater legacy protection than a will. A lot of times a will says, look, when I die, everything goes to the 3 kids. That's it. So here's your check. We stuff that money in their pockets. If they've got creditor issues or they're going through a divorce, that's not going to help them, right? That's probably just going to hurt them, frankly. But a trust can protect your legacy by creating structures that allow the individual, like the child who's inheriting, access to the funds, but protects it from the child's creditors, including potentially a divorcing spouse, which we see as the single biggest threat to the creation and preservation of multi-generational wealth is marriages ending and then some of these inherited assets being split. Now you might say, well, Jim, isn't an inheritance separate property? It is, but separate property, at least in California, can easily become community property, right? Through maybe some inadvertent things, maybe you say something, maybe you spend the money in a certain way. So there's no guarantee that just because an asset is inherited, that it remains separate property for the duration of the marriage. In fact, a lot of times that's not the case. It can also go affect support, child support, spousal support. So there are a lot of other things that separate property can have a negative effect if the person who's inheriting from you gets a divorce. That's why we look at these structures to keep that out of the individual's name who's inheriting, and in a trust for their benefit. So let's look at a living trust versus the probate cost. So, I mentioned if you have a living trust, well, you got to set up a living trust. Let's say a person doesn't have a will, they die without a will, they die intestate, they're going through a probate. But if you set up a living trust at Cunningham Legal, I would say the vast majority of people who do estate plans in our firm, it's somewhere between $5,000 and $10,000. Can it get over $10,000? Yes. If you've got a $30 million estate and you got a bunch of LLCs and a bunch of complicated stuff, it's going to typically push you over that amount. If you have a factually complex estate, if you own interests in 30 different LLCs and those need to be transferred to the trust and you need to be working with the various managers of the LLC, that is what might push up that figure. If you have a larger estate and you're maybe doing some sophisticated irrevocable trust planning, that's where you get higher. But I would say for the bulk of our clients who say, Jim, we want to set up a living trust centered estate plan. We want to do the living trust, the wills, the durable power of attorney for property, durable power of attorney for healthcare, deeds. What does that cost? I would say, broadly speaking, 5 to 10 is the realistic sort of range. That, some attorneys out there will discount their fees below that, but I will tell you, it's very hard to employ people in California, paralegals or other attorneys, and not charge that dollar amount for an estate plan. Why? Because it's very expensive to do business in California. Some people do charge less. I put those in the class of irrational competitors. So these are people who say, oh, well, they're charging more, I'm just going to charge half that. Well, okay, but those people don't tend to be around, or maybe they're cutting corners in a way that you don't know how they're cutting corners. So estate planning is very complex, and we want to do a good job for our clients. So what do you get at our firm when you do this sort of $5,000 to $10,000 estate plan? You get a team of experienced lawyers. So you're meeting with a lawyer. You're not meeting with a paralegal. We have experience, a lot of experience in multi-generational wealth planning, also multi-generational trust administration. So that's all the stuff that happens after somebody dies. So we have a lot of experience in that. We know what not to do, and that's why experience is important, is you know what not to do. We have customized strategies for creditor, predator, and divorce protection. Now, this is going to be typically for the people who are inheriting from you, and guidance from a trusted firm with a proven track record. So we've been around 30 years. We've helped thousands and thousands, probably tens of thousands at this point. Our firm has over the years. So we really know what we're doing. There is a fee for an initial consultation in addition to the above fees. So our firm, we charge for initial consultations. Not every firm does. I would say most people who know what they're doing are now charging for the initial consult. It's sort of a post-COVID just change in the world. But you can visit our YouTube page if you're looking at this on YouTube. You can kind of look at the different videos we have, and also our website, CunninghamLegal.com, for more details on that. And we walk you through how that works. But it's something you can reach out to us and we can talk to you one-on-one. So let's look at the living trust versus probate. I just want to give a visual. We're going to have $1 million estate and a $10 million estate. The example here of $1 million estate is a home in Sacramento, in East Sacramento, in the thrifty 30s. So there's the fab 40s in Sacramento. The thrifty 30s are in the 30s. So this 1278 33rd Street, I know exactly where this is. 2-bedroom, 2-bath home, 1,300 square feet, $655,000. Plus this. In this example, they have $345,000 in other assets. So let's assume we go through a probate. Now, what does this look like? Well, if this person dies with a will, it's $46,000 plus another $2,000 or $3,000, so close to $50,000. The property, if you're not paying attention, your property taxes are going to go up. So even if a child inherits this, and we talk a lot about Prop 19 here, which allows, in many instances, the parent to leave the property to a child, and that child's keep the parents' low property taxes. But there are time limits on that. And if you don't get your probate closed fast enough, right? If you don't do anything for 3 years, you're going to lose this benefit, right? So you need to get in, you need to take care of these things in order to preserve this lower property tax. So no estate plan, $50,000, probably 2 years, higher probability of not of losing this $1,200 a year benefit of keeping the lower property taxes when you inherit the parent's house, versus setting up an estate plan. And this is probably a $6,000 estate plan and maybe a $5,000 trust administration, kind of assuming 1 or 2 kids, not a lot going on, not a lot of drama. Yeah, you're going to spend 10 grand, $11,000. You're not spending 50. Right? You're spending 20% of what you would otherwise spend. Now, if one child says, oh, I'll be the executor, but not charge that $23,000 fee, that would cut that cost, but you still have a $23,000 attorney fee, okay? And the publicity of probate, and you have the 2-year, essentially 16 months to 24-month time period. That assumes if everything goes right, by the way. So most of our probates are at least 16 months for a lot of different reasons. But a lot of times there's weird stuff that happens in a probate. You might get into a dispute with a creditor. Probate is, you have to notify creditors. We'll talk about that. If a creditor says, oh, you owe me $5,000, and you say, well, no, I don't, you're going to have to deal with that in the probate court, right? So on $1 million estate, the creation of the living trust, the administration of the living trust is $11,000. That's not the 40. That should be $46,000, not $42,000. So we are saving $35,000. Is what that should be. So the numbers are a little bit, so it should be $45,000 in savings. Let's look at a $10 million estate. So $10 million estate takes a little bit longer. I would say 16 to 36 months, 12 months, but you might have this 36 months because you might have some tax issues, right? You might need to file the last income tax return and get a tax clearance certificate from the state of California. You might have federal estate tax filings, maybe not necessarily an estate tax paid. You might have some state inheritance tax. We'll talk about that. But in this example, on a $10 million estate, you're saving almost $200,000. You're saving $191,000. And what we did is we assumed $10,000 to set up the estate plan on a $10 million estate. Typically, there's more going on. And then $25,000 for trust administration. Why is it higher? There's typically a lot more going on a $10 million estate. But again, you're way ahead of the game, right? You're way ahead of the game. So looking at this, again, a slightly different way. This is a $10 million estate. we are looking at 226,000 in probate fees. We have increased property taxes. We've got some income taxes and some federal income tax and state income tax on an IRA because we're assuming a $5 million IRA here. There's a lot going on. $2.5 million. Okay. If you go through a probate and you don't plan a $10 million estate well, $2.5 million goes out in probate fees, paying taxes on the IRA because maybe the IRA was left to the estate, okay? And all that money has to come out in 1 year. You know, you might be able to spread it out over 5 years, but I'm assuming you totally drop the ball on everything and you pay all that income tax on that IRA first. That's $2.5 million. Estate planning, probably 50,000 all in. You know, executor fee or trustee fees, attorney fees, significantly less. Now, that's not avoiding a $2.3 million on income taxes on the IRA, but it might be deferring them 10 years. We might be able to spread that out over a longer period of time, depending on who's inheriting and what structures we're using. So the point of this is to highlight that if you have a larger estate, you know, if you have a few $1 million IRA, you've got a couple of pieces of property, it is very important to have proper estate planning because all this money is due, might be due right away, and it might require you to drain that IRA down, which you spent your life building up. So the idea is with proper planning, we're going to mitigate, we're going to defer taxes as much as we can, and we're going to try and pay less taxes overall. So that's the idea, is you want to defer that or get rid of that big old bill. Probate is public. Probate is not private. So this is very important. What does not private mean? Well, a living trust is private, but of course a probate, and this is if you have a will, so a will does not avoid probate. If you have this will, all the court filings are public. Anyone can go to the county clerk's office and request to see the probate case by file by name. I want to see Jim Cunningham's. You know, if I had a probate, I want to see Jim Cunningham's probate file. Okay, here you go. And you get to look through that and you get to see all this juicy personal information. Well, information of a decedent, I guess it's no longer personal because the person is deceased. But what can you see? You can see the will, the petition for probate. Now, this will typically list the heirs. It will have a broad, kind of a high dollar amount. Like this is the value of the estate. So there's a requirement that you kind of recite the value. There's an inventory and appraisal that is filed later in the probate process that itemizes each bank account. Bank of America, $100,000. Wells Fargo, $350,000. Apple stock, 16 shares, whatever it is. Everything's going to be listed out individually, completely public, a matter of public record. Accounting, income and expenses. How much money came in? What were your expenses? Who did you owe money to? Matter of public record. Court orders and rulings, all matter of public record. Some counties have online search tools where you can pull this up or you can open up an account. Again, there are data resellers that are reselling this data. But my point is, with probate, this is a public proceeding. You may not want your future ex-daughter-in-law to know how much your son is inheriting, okay? Think about that, right? Your future ex-daughter-in-law. So probate requires a public notice in newspapers. Yes, these are the things that are paper and they have ink printed on them and they get dropped off regularly somewhere now. I don't know where you would drop a newspaper off. I have no idea. Maybe the local 7-Eleven. But again, probate still has this requirement that it be published in a printed newspaper. And this informs creditors that this person has passed away, as well as potential heirs. And we've got two examples here. One is from Canada, from Saskatchewan. So yeah, probate is in other countries. And this is here to remind me that if you have property in another country, if you have property in Mexico, if you have property in Canada, if you bought one of those €1 Italian villas that my wife wants to get, that I pointed out is in a place that she probably doesn't want to spend any time in. If you have that, you need to reach out to an attorney in that particular country to deal with that asset, okay? Now, the reason is your living trust might say a lot of stuff about how you want your Italian apartment distributed, but ultimately that's a question of Italian law because that's where the dirt and the bricks and sticks and the stones and the beams and all that, that's where that's located, right? So ultimately, Italy's going to have say. Same with Mexico, same with Canada. This other one here goes back all the way to 1835. So we have probate notices that go back a couple hundred years. So that's out there in the public permanent record forever, and that is probate. Creditor exposure. The notice of probate gives creditors an open invitation to file claims. Now, it's not that hard. It's a 2-page form. I'm a creditor. I fill out the claim. I don't even have to pay a filing fee. I just file the form, right? So I filed that form with the court. And then as the executor has to deal with it, the executor either accepts it and says, yes, this is a valid creditor's claim, or no, this is not a valid creditor's claim. Then the creditor has a period of time to initiate essentially a lawsuit, or they can be, I agree to part of it, but disagree in part of it. And then that would be like a partial acceptance. So you would still have that same potential litigation for the creditor saying, no, I think I should be paid the full amount. So in California, creditors have 4 months from the appointment of the personal representative to file their claim. So the notice of petition to administer estate is published in the newspaper. Once that's published, letters are issued, and 4 months from that date, so 4 months from the date letters are issued, 120 days, the creditor has that time period to file a creditor's claim. If the creditor files a claim 130 days after, that is a late claim. That is not a valid claim. The executor cannot accept that claim. They cannot pay it. It would be a breach of the executor's fiduciary duty. So in trust administration, and this is with a living trust, there's no public notice requirement. Now there's actually a notice procedure with trust that we don't use a whole lot. It kind of mimics probate, but there might be some use cases for it. But I would say, broadly speaking, the vast majority of people with a living trust, no public notice. Creditors are not automatically alerted to the decedent's death. There's no statutory creditor window like there is in probate. Creditors must take extra steps, and even sometimes they might have to start a probate in order to file their creditor's claim. And all of that has to be done within 1 year of the date of death of a decedent. So let me say that again. With a living trust, I die. My creditors have 12 months to come forward under California law. This is with probate, without probate, with a living trust, without a living trust. If they don't come forward within a year of my death, that cuts all limitations of actions statutes or statutes of limitation. So if somebody says, well, Jim, I think you owe me money, and I say, well, no, I don't, and then I die, that person might have 4 years to make a claim, like breach of contract. They might have 4 years to claim against me personally, but when I die, that 4-year time period is shrunken down to a year from my date of death. So that's Code of Civil Procedure, Section 366.1 and 366.2. It's in the California Code of Civil Procedure. Very important provisions to understand, because in the real world, trust administration, somebody passes away, a couple months later, they come in to see the lawyer. We're not notifying creditors. Creditors typically come forward, but if they don't come forward within a year, they're barred. Now, if you're married and it's a community debt, you get into different issues. But broadly speaking, there are time limits on creditors filing creditor claims. That's why living trusts are better, because with a probate, you affirmatively have to notify the creditor and say, oh, by the way, if you want to file a claim, here's where you file it. Here's the case number. Here's the court. So it makes it really easy for the creditor. So let's look at an example. Mary has a $900,000 probate estate. Her estate is required to publish the probate notice. An old business partner the family's never heard of files a claim for $85,000, says Mary owed him money from an informal loan decades ago. So this guy says, well, I lent Mary some money, and now I think that the amount I owed is $80,000. Additional scammer creditors reach out. They go, oh, well, I was owed $5,000, I was owed $10,000. Probate requires that all these claims are formally responded to. Either you have to settle, reject it, or accept it in part or reject it in part. Probate fees are $40,000 in a $900,000 estate. So here's the lesson on this. Not only is probate expensive, it opens it up to all creditors, even the ones that are kind of bogus creditors, right? And maybe they're scam people from North Korea or wherever that are trying this game, and they're trying to scam people in probate. But even people you have no idea about, right? You have no idea who these people, I've never heard of this person. They file a creditor's claim. They come forward. You're going to have to deal with that as the executor. So you're going to have to deny it, accept it, and just deal with it. But not with the living trust, right? So how can not having an estate plan lead to conflict? So what we're talking about is the absence of an estate plan. Here's the problem. If whether you do a will or don't do a will, or do a living trust or don't do a living trust, right? The state of California and every state has an estate plan for you. Now, what that estate plan says is if you're married, that your spouse gets all of the community property and some of the separate property. Your kids get another part of it. So if you don't have a will and you're married, the threshold question that we have is the property community or separate property? That pits the surviving spouse against the children of the deceased person. So that can generate family conflict. But if there's no will or trust, the state of California, the state laws of intestacy, somebody dying intestate without a testamentary document like a will or trust, the heirs are going to disagree on what would mom and dad have wanted, right? If we've got kids and parents. So two siblings both want the family home without clear instructions. It's a battle. Who gets the house? They're not going to split it. One wants the house. They both want the house. Who ends up with it? That's just something that's going to have to be dealt with in court, right? What if distribution's unfair? What blended families, stepchildren? What if one child was the caregiver? What if you have one child who's been taking care of mom and dad for 10 years and now they got to split everything equally? Is that fair? I mean, it might be fair. It might not be fair. I don't know. These are questions that are highly personal that whether you're the child or the parent, you should really be thinking about. Blended families are tougher. Blended families, kind of like what I mean by that, like the Brady Bunch. He brings in 3 kids, she brings in 3 kids to the marriage. They get married. They've got 6 kids together. Well, if Mike Brady passes away and leaves everything to Carol, remember the Brady Bunch, right? Then Carol says, well, everything's in my name. I'm just going to leave it to my 3 girls. Even Mike's stuff I inherited. And then Mike's children say, well, Carol, that's not fair. We think we should be entitled to some of that. So that would be an example of how not having an estate plan could engender some animosity. Conflict over decision-making power. Big deal. Family members often fight over who should make decisions, especially in sort of a high-stress medical situation like incapacity. Well, I don't think dad should go to a nursing home. And then your sibling says, well, the doctor said he needs to go to a nursing home. And, then you've got this sort of conflict about who decides where dad goes. An estate plan, a well-written estate plan should, that's not a guarantee, but it should deal with a lot of these conflicts. What taxes do estates face? So what are we talking about? Taxes due from reassessment on property can typically run in the thousands of dollars, meaning your property gets reassessed. I inherit my parents' home that's worth $3 million. The assessed value is $300,000. My taxes are going to go up tenfold. They're going to go from $3,000 to $30,000 a year, right? So that's one type of tax. And this, a lot of times, I think too many estate planning lawyers don't think about property taxes as kind of being a death tax, but really that's what it is. Because when your parents pass away and you inherit that property, it used to be that you would keep their low property taxes by and large. Now that's gone, except for the family home, right? And we cover that in other webinars. Federal estate taxes are 40% on amounts over, that should be 15 million, not 10 million. So 40% on amounts over 15 million. That's the latest iteration of federal law. Individual retirement accounts can be as high as 90.3%. So these are another taxes. Now you might be saying, Jim, what are you talking about? I'm talking about 40% federal tax, 37% federal income tax. So 40% federal estate tax, 37% income tax, and 13.3% California state income tax. That's 90.3%. We cover this in other webinars. There is a federal deduction for estate taxes paid. It's a little bit like getting a VAT refund if you've ever gone to Europe and you're kind of scrambling at the airport trying to get your papers filed, and a little bit like that. I'm not sure how many people actually track when they inherit an IRA and pay estate taxes, how to get that federal tax benefit over the next 10 years. State death and inheritance taxes up to 20% in Washington. So this is typically on amounts over a little bit over $2 million. But in Nebraska, the tax starts at $17,000 in assets. So there's two things going on here. Washington says we're going to impose, and this is the highest, this is why I put it in there, a 20% death tax on everything over a little bit over $2 million. Nebraska says, hey, anything over 17,000, right? Or some inheritances over 17,000, we're going to impose a tax of 1 to 8%. So you have to look not only at the percentage that each state is charging, but also the threshold, like where does that kick in? So this is really important. If you're a California resident and you have a vacation home in Washington, that is going to subject your estate to Washington inheritance tax. Now, Washington likely will put the value of your property in Washington on top of all your other assets. So if you say, gee, well, I've got, the property's worth 500,000, but I only have the 500,000 in Washington, so it's under that $2 million threshold, but I have a $10 million estate in California, they're likely going to include that 10 million for the purposes of calculating the Washington inheritance tax. So a little bit of a complicating factor, but this is the point I'm making with this. If you're a California resident, you're really not thinking about death taxes because California doesn't have a separate death tax apart from this like real estate and inheriting a parent's property. I suppose you could call that a death tax. Other states have a death tax, meaning you look at the total value of the assets, they're going to impose a percentage on a certain portion or potentially all of those assets, certainly that are located in that state. If you're a Washington resident, game on. I mean, all your assets are going to be included, right? So if your domicile is Washington, if you say, I'm out of here, I'm leaving California, tired of paying the state income tax, I'm going to Washington, where there's no state income tax, you have just landed in a place that charges your estate 20% on amounts over $2 million, 20% federal state death tax. So pay attention to that. It is better to inherit something versus being gifted something. Now, the downside is you have to wait till somebody dies, but I would say it is generally better. Now, and this answers the question of, well, should I give my home to my kid, right? Should I give this asset to my child while my child is living and I'm living, and or should I wait till after death? Assets that are included in your gross estate, which is a legal way of saying anything that is subject to federal estate taxation at your death. Now, if you have a $10 million estate, your estate is subject to federal death tax, but there's no death tax until your assets exceed $15 million. I'm assuming no lifetime gifts. So as long as those assets are included in your estate, it's what lawyers say, includable or included in your estate, these assets get what is called an adjusted cost basis. What is that? It means if you pay $1 for Apple stock, that it's now worth $100 a share, or whatever it's trading for, when somebody dies and you inherit that stock at $100 a share, you can sell that stock for $100 a share and not pay capital gains tax. If they give you that share of Apple with a $1 cost basis, you're going to have a capital gain of $99 on that share, and so you're going to pay $33 in capital gains tax. So it is better, whether it's real estate, stocks, whatever it is, it's better to inherit that than have it be gifted to you. So this can significantly reduce or eliminate capital gains taxes if the asset is sold shortly after death, meaning there hasn't been a change in value. If it's rental property, residential, commercial rental property, that starts being redepreciated after somebody passes away. So if you wait 5 years and you sell it for the date of death value, you might pick up a little bit of gain, a little recapture of depreciation. But these are just things to think about. And one of the reasons I do these videos and audio is so that people can hear this literally like 25 times, because you need to hear this a lot for it to sink in. Big picture, it's better for the recipient to get something after somebody passes away than while the donor or the giver of the asset is living. So when the asset's given during the owner's lifetime, the recipient takes the original cost basis, right? So that example of Apple, so instead of you getting a cost basis of $100 a share, it's $1 a share. So son inherits a home following mother's death. Mother had bought the home for $100,000, and at her death, it's worth $1.1 million. The son saves in California about $371,000 in capital gains taxes by inheriting the house versus mother giving it to son during her lifetime, okay, during the mom's lifetime. So very, very important. More than just money. Now, whenever people say it's not about the money, it's like, come on. When it's about the money, people say it's not about the money. But there's more than just money going on. And I do want to focus on this public process, okay? Maintaining family privacy. I mean, what if you have a $100 million estate? Do you really want that public? That's going to be public forever. We had an example of here. There was a probate filing from 1835. This information is going to be public for multiple generations. Most people want that private, right? Most people don't want that out there. Probate can take months or years. Months or years. Years. Probate is emotional, always emotional. I've never seen a probate not be emotional, okay? You're dealing with very complex feelings, drawn out over a long period of time. When my mom, her mother died when my mom was 11, and then her dad died when my mom was, I don't know, in her 50s. And then she says to me, I'm an orphan. And I thought, well, that's kind of odd. I mean, I was a younger adult, but it's emotional, right? And she didn't go through probate with my grandfather, avoided probate, but it was still emotional. When you have this probate layer on it, it's even that much more emotional for a lot of people. Executors can face significant responsibilities and potential liabilities during probate. If they do something wrong, they're personally liable. And a lot of times it's a judge. Maybe the whole family agrees that the executor should have paid that creditor claim because it was from Aunt Sally who, paid for the funeral or whatever. But if that creditor's claim is filed late, the judge says, no, you cannot pay Aunt Sally, even though she paid for the funeral. And oh, by the way, executor, you paid Aunt Sally, so now I'm going to make you pay that money back to the estate. So you have to pay out of your own pocket. So a lot of drama. Preservation for business if you own a business, the last place you want to be is probate, because guess what? You have to make payroll, and you're going to be making payroll either, typically every 2 weeks, sometimes every week. But if something happens to you and you have a business, how are your people going to get paid? And by the way, if you don't pay people timely in California, there are significant mandatory penalties for not paying. That is like one of the worst things you can do in business, is not pay your people timely. So very important to have some type of succession plan, some mechanism to make payroll if you kind of get hit by the ice cream truck and don't make it, right? So you need to decide where your assets go in estate planning. You get to decide this, not a judge, and that's very important. Most people don't want a judge making those decisions. The estate plan bundle. What are we talking about? Estate plan bundle. An estate plan is a living trust. It's also a lot of other things. When people do a living trust in California, we also do something called a pour-over will. Some attorneys call it a pour-over trust. A pour-over will says, I have this living trust. Anything that's in my name that might be like, I forgot about that $10,000 bank account. I forgot about the shares of Disney that I bought 30 years ago that I never put in my trust. My will leaves everything to my living trust. Okay? Everyone should have a will. I mean, even a homeless person should have a will. Everyone should have a will, because it says where your stuff goes. Whatever stuff you have, it says where that goes when you pass away and who's in charge. So pour over will, everything to a living trust. Nominations for guardian, that's if you have minor children, very, very important. Beneficiary designations are part of the estate plan, part of the bundle of documents, but this is very important, and we discussed this in other webinars. Your IRA, your annuity, your 401k, your life insurance, those pass by beneficiary designation. It does not matter what your living trust says. That has no bearing on who gets your IRA or your 401k or your life insurance. Let me say that again in another way. You go out and you set up this living trust, and you say, I want to leave everything equally to my 3 kids. And then on your life insurance, you name your oldest kid. And you say, well, I'm naming my oldest kid because they're the trustee. And this is a very common mistake. I'm sure they're going to do the right thing with the money. Well, that kid, when you die, gets the life insurance policy and has no obligation to share that with the other 2 children, okay? And that child may have a spouse in the ear saying, well, I talked to a lawyer and you don't have to share that with your siblings. And, your kid's saying, well, I want to see my siblings for Thanksgiving in the future and I don't want them to hate me. So it can really set up a tough situation. But the idea there is just for you to be aware that the IRA, 401k, life insurance, annuity, especially the 401ks and IRAs, for many of our clients, that's more than half their estate. They've got a house and big IRAs. Like that's what they've got. That passes outside of your living trust. Powers of attorney for healthcare, including HIPAA authorization. So power of attorney for healthcare, someone makes medical decisions for you. Should you pull the plug? Should you not? HIPAA authorization gives people access to your health information. So the nuance here is the Advanced Healthcare Directive says, I want this person to make decisions for me if I cannot make them for this myself. The HIPAA authorization just is a blanket grant of authority to people to access your medical records while you're if you're healthy or not, right? Even if you have capacity, you can grant someone permission to access your health records. And also the Power of Attorney for Healthcare, Advanced Healthcare Directive, slightly different documents. We kind of use those interchangeably. Power of Attorney for property, so the durable power of attorney for property management and personal affairs, is the document that says, hey, if I'm sick, I can name my wife to to deal with my IRAs and my 401ks and my annuities, deal with all the stuff that's not in a trust. So you have your living trust that has your home, your stocks, your bonds, your mutual funds, does not have your IRAs, 401ks. You still need the durable power of attorney to deal with things that are not in your living trust, like your 401k or your IRA, and then deeds to your property. So we transfer property. That's how we transfer real estate into your trust. You don't just list it on a schedule of assets. You do a deed from Jim to Jim's trust. Right? That's typically what we see. So again, how does a living trust work? It's like a bucket with a handle. So if I create Jim's trust, I've got this bucket and this nice handle. I'm the trustee. I'm holding onto the handle. Into that bucket, by deed, I transfer my house, stocks, bonds, mutual funds. I retitle those accounts into the name of Jim's trust. My IRAs, 401ks, annuities, life insurance stay outside of my trust. Very, very important. When I die, whatever my trust says has no bearing on who gets my IRAs or 401ks. And a lot of people don't really think about this. They might know it, but I sound like a broken record on this one, but believe me, this is really important stuff. All trusts have a trustee, which is the person who's in charge of stuff, a beneficiary, that's the person who gets the goods, the bene from Latin, the goods, and a corpus, stuff, right? So the goods, the benes. So you have to have these three things. If I'm holding onto my trust and my handle, and then I stop being trustee, let's say I die, that bucket passes to the next trustee who's called the successor trustee. So let's say it's my wife. She now is the successor trustee. She's holding onto the handle. She's now just known as trustee. We drop the term successor trustee. This avoids probate at death, also avoids probate at incapacity. Remember, revocable trusts typically become irrevocable at death or on the death of both spouses. And a revocable trust can be amended during lifetime. An irrevocable trust cannot be amended. So let's look at a kind of a typical estate plan. We've got Abel and Baker. Baker dies, the B spouse, the buried spouse, the below ground spouse. Baker dies, Abel survives. There is trust administration. Abel will hire our firm, Cunningham Legal, to do a bunch of stuff. And remove Baker's name from deeds, remove Baker's name from title. Make sure the terms of the trust are followed. At Baker's death, is anything going to anyone? And then also Abel will probably end up filing a Form 706 federal estate tax return. So Abel can pick up Baker's $15 million deceased spouse unused exemption. So what that means is Abel can inherit Baker's ability to leave $15 million tax-free and combine that with Abel's ability to leave $15 million tax-free for $30 million. And you might say, Jim, well, we have $2 million. I don't know why we're worried about this. It may be that the law could change in the future, and that estate tax exemption for Abel, when Abel dies, could be $1 million, could be $500,000. We don't know, right? I have no idea what's going to happen. That way, Abel's picking up Baker's deceased spouse unused exemption. Again, we cover that in other webinars. Then Abel passes away. We go through trust administration again. Remember, when Baker passes away, Abel gets an adjusted cost basis on assets. So Abel can sell the Apple stock and not pay capital gains tax or hold on to it. Abel can sell the rental and not pay capital gains tax. Same true as with once Abel passes away, again, all the kids can sell those assets tax-free before they go to the 3 children. This brings us to the end of our time together. Our materials here, we do have office locations in Northern and Southern California, very close to where many people live in California. And next week, we have Angela Gualin Lee from our office, who is an attorney who is licensed to practice in California and China and New York. She will be doing this in Mandarin. This is pretty cool. This is a beginner's guide to trust and estate planning, avoid probate, save taxes, and protect your legacy. That is what Angela will be covering in Mandarin, and she is a native Mandarin speaker. So we're very excited about that. We also have a Russian language webinar on a similar topic and Spanish language. So we have, we like to get these out in languages, different languages other than English. A lot of people who live in California, their first language isn't necessarily English, and it's nice to hear it from somebody, a familiar voice, let's say. So next time, and then after that, August 21st, we are going to have Prop 19, what homeowners should know. There have been a lot of developments in Prop 19. I believe we're actually going to be moving that date a little bit earlier than the 21st of August. But I would definitely go to our website and sign up for that one if you're interested. And if you're watching this on YouTube, please subscribe to our YouTube channel and click the bell. You'll be alerted when we drop new content. And we're going to open it up for questions. So you've made it to the end. If you've been watching this on YouTube and if you fell asleep, okay, wake up. We do questions on webinars. We don't put these on our YouTube page. If you want to ask questions, come to a live webinar, go to our website, sign up for a webinar, show up. We cover the questions at the end, and that's what we're going to do. But if you're watching this on YouTube, keep watching this because magically another video is just going to roll right after this one. And thanks for joining us.